rise. The Court of Appeals, Division 1 is now in session.
Please be seated. We're here in our case 1CA-CV17-0377, MACKAY versus Auto Owners Insurance. Each side will have 20 minutes to present their argument. Appellant, you may reserve any time that you want for rebuttal, but you'll have to keep track of the time yourself as we're able to click at the podium. We are recording the argument, so when you begin your argument, please identify yourself and your client so that if we listen or watch the argument later, we'll be able to keep everybody straight. We've read the briefs and looked at the record. We've conferenced the case, so we're familiar with the facts and the argument. So when you begin your argument, just start right out with what you would like for us to know. Counsel, you may begin.
Thank you, Your Honor.
Good morning. May it please the court, my name is Jeffrey Victor. I'm the counsel for the appellant, Mary MACKAY. Also present as co-counsel is Scott Bain for the appellant, Mary MACKAY. If I may, I just want to spend a minute or two going over some of the salient facts of the case because they dovetail into the argument. As the court is aware, Andrea Cash purchased this property as a form of investment to become the landlord. She was never on the property the entire time from the point where she was contemplating the purchase, or during any of the leasehold interest. She never inspected the property during her ownership, nor did she have any of her agents inspect the property. Once the litigation started with regards to Mary MACKAY, Miss Cash was nowhere to be found, and she failed to appear at the deposition. Cash, through auto owners, wants to argue that she had no notice of the dangerous condition.
Well, let me stop you there and try and organize this in my own mind.
Okay.
She wants to argue that she had no notice, but as I see it, there are really three issues we're concerned with. The first is whether a duty existed. The second is whether, if a duty existed, there can be strict liability theory in the case. And the third is what on earth we do with this negligence per se ruling, given that it was the mere denial of a motion for summary judgment. Do you see it differently?
No, I agree with Your Honor.
Okay. Well, let's save some time for the third, because I'm confused about our procedural posture and I'd like both sides' input.
And perhaps if it's okay with co-counsel, I can reserve a minute or two if Mr. Bain would like to address the third issue that Your Honor has raised.
That might take more than a minute or two, but let's not chew up your time now.
Okay. Thank you. From the testimony and from the discovery in this case, there were two previous tenants prior to the Hamilton leasehold interest. There was a gentleman by the name of Scott Bostic who testified that a roof tile had fell off the porch. He himself chose to replace the tile. More importantly, there was a Carrie Holmes who was the prior tenant to Mary Hamilton. And she testified that there were two roof tiles that blew off the roof. She called Tammy Fernandez, who was the property manager or agent for Andrea Cash.
Does that have anything to do with the mechanism of injury here, though? As I understood it, the swing caused problems unrelated to roof tiles.
No, not necessarily. There was a porch swing that was installed with their permission, or they acquiesced to it, but the roof was in extremely poor condition, as was discovered by Steve Heather from the city of Mesa, and there were several code violations with respect to the roof. So when Miss Reholmes calls about the two tiles, because this goes to the issue of notice and whether they should have been on notice, apartment finder hunters, Tammy Fernandez sends somebody out to fix the two tiles. At that time, more likely than not, one would see inadequate flashing, inadequate underlayment, the beams are rotting, the straps are rotting, lag bolts are missing. So to argue that they had no notice when they actually sent someone out during the rehome leasehold interest to make the repairs is contrary to the facts in this case, and that's the only reason I bring that up. The other issue is...
So your contention there, if I can organize this,
Sure.
is that there is some evidence of breach of duty, but you're not really talking about the existence of a duty right now.
Well, I'm talking about the trial court made the ruling that there was no notice.
Well, leaving
Right.
the trial court's ruling aside for a moment,
Sure.
the points you're making right now, I think properly compartmentalized, would go to the breach of duty rather than the existence of duty. Do you agree or disagree?
With all due respect, I disagree, because the court takes the position, the trial court took the position, no notice, no duty.
Right, but the Supreme Court is the one that I'm more concerned with, and the Supreme Court, it seems to me, reading Gibson, would not be terribly interested in facts concerning falling tiles in establishing whether there's a duty. The Supreme Court seemed to tell us to look elsewhere.
Well, yes, if the case law is such that you don't need actual notice to as a predicate to duty, but if this court says that there needs to be notice, that's a question for the trier of fact, because there is a complaint about carpenter bees burrowing into the porch posts.
All that goes to the content of the duty, not to the existence of the duty. Isn't the existence of the duty simply a binary legal question? We say yes there was or no there wasn't, and if there was, we do very little to inform the participants about what they need to prove, but we do resolve the issue in this appeal.
I agree.
Okay.
I agree.
The trial court found no duty here.
Correct.
And your position is that's because there was no notice. But as Swan said, notice seems to go to breach rather than duty. Is your primary argument that there absolutely is duty here? Notice aside.
Well, my primary argument is, Your Honor, is that notice is not required because it's an absolute duty. You have the Landlord-Tenant Act, and you have building codes, and and it says that the landlord shall do whatever is necessary to maintain the property in a fit and safe manner.
Well, then I guess that sort of brings us to the next point, which is what you're saying sounds an awful lot like strict liability, and that would be a new one on me. I think it would be a major shock to the community of landlords in this state if they knew that they were subject to strict liability for everything that happened on their properties.
Well,
I've never known that to be the law. Are you suggesting that it is?
Well, as a practical matter, how do you comply with the Landlord-Tenant Act and the building codes if you don't periodically inspect and discover the conditions or the defects in the condition? It's an implied duty. in order to carry out the purpose of the Landlord-Tenant Act and the building codes to promote the health and safety of the tenants and their guests, it's an implied duty that periodically someone, the one who's in the better position, the landlord, will inspect the property to make sure that it's compliant.
Well, you can make that argument, but that's very factual. Let's say that there's some natural disaster. There's an earthquake that causes an otherwise well-maintained property to be out of compliance briefly with the Landlord-Tenant Act, and the day after the earthquake, a tenant is injured. Wouldn't we need to inquire whether the landlord's conduct was reasonable and not just say, well, your property was out of compliance for those few hours and you're liable now?
I agree with you 100%.
Okay.
But that's different than what we have here.
So you're not saying that the very fact that the swing fell and the roof collapsed proves your case. You agree that you have to prove there was some negligence in addition to having the duty to maintain the roof.
Oh yes, there's a duty that's imposed if by no other means by the statute and the building code. It's imposed upon the landlord.
But if your contention is that the lack of compliance with the building code can be a basis for liability itself, that's still a fact-sensitive inquiry, it seems to me, because you still have to see whether that lack of compliance was reasonable in the circumstance and whether the landlord took reasonable measures to comply before there's liability. Would you agree?
No, I agree. Your scenario is correct. If there was an earthquake and for whatever reason, the landlord couldn't get out there or send somebody out there, and the next day something happens and hurts someone, that's a factual question whether that conduct is reasonable to delay.
But that's a big difference then between asking whether the conduct was reasonable and strict liability. It sounds like what you're describing right now is not a strict liability theory, but rather the building code imposing certain standards of care,
Right.
which are potentially legitimate goalposts in a negligence case, but they are not a strict liability case.
No, but it puts a burden upon the landlord to act in a reasonable manner because of the code and because of the statute. So then the question is, if they don't do any inspections over 9 years, if tiles are blowing off the roof, they have an opportunity to see what's going on if someone goes out. If a tenant is complaining about carpenter bees burrowing, is the conduct reasonable by not taking further action and inspecting?
And the lack of an inspection may not matter. If the landlord and tenant, let's say, are related to one another and have a very good line of communication, the landlord may, in some cases, reasonably rely on the tenant to do the inspections herself.
Sure, if there's some type of a wording in the lease agreement that shifts the responsibility to the tenant, or there's some course of conduct that the tenant has assumed that responsibility, I agree with you, but that's not the case here.
There's no wording in the lease agreement. If there's a course of performance, there may be. All I'm saying is all of this goes to the factual nature of each case. Each case has to be decided on its individual facts. We don't simply have black and white rules that are going to give you a result regardless of the facts.
We don't have black and white rules that give you a final result, but we do have rules in this case that point you in that direction, and that's my argument, basically.
But all you're asking for is an opportunity to prove all that.
Yes, sir. Yes, Your Honor.
You don't have to try to win your case here.
I understand. At a very minimum, it's a question of fact for the jury. And just briefly, with respect to Tammy Fernandez, she testified in her deposition, page 22, line 23, to page 25, line 4, that walkthroughs were required with respect to each lease at the outset. She also agreed on page 71, line 24 to page 72, line 5. She agreed that periodic inspections were required, which were not done in this case.
Well, counsel, I apologize. I take your point, but I don't understand why you're arguing that to us today. It seems like those are factual matters that we can't resolve today. You need to go back to the trial court and argue that.
I'll move on. Thank you. In the Cummings versus Prater case, the court in part looked at the case of Johnson versus O'Brien, 258 Minnesota 502, 105 Northwest 2nd 144. And that case said, the court held, to the extent that the rule in these cases might be interpreted as meaning that the actual knowledge of the defects on the leased premises constitutes a prerequisite to the liability of the landlord, they are expressly overruled. So Cummings versus Prater and Johnson versus O'Brien say you don't need to have actual notice as a prerequisite for an actual duty.
So does notice go to foreseeability?
Notice, there's two arguments here. The one argument is they had no notice, but then the other argument is what facts did they know of that would make it foreseeable that to a reasonable person that a dangerous condition exists. And they certainly had facts that they were on notice that to a reasonable person, again, a question of fact for the jury.
The recent Supreme Court opinion said that foreseeability doesn't go to duty, it goes to the question of breach.
That's correct.
So it seems like all of the issues about notice and foreseeability go to breach and not to duty. Is that correct?
It's correct, but I bring it up because of the holding in Markowitz versus Arizona Park Boards, and also the Piccolo versus Woodall case, which states we hold a landlord owes a duty of reasonable care to his tenants, which includes an obligation to inspect and warn of any hazardous conditions on the leased premises, and it talks about whether or not they knew or should have known based on the facts that there's a potential dangerous condition.
Our time is growing short, so
right.
I'd like to ask why should we even address negligence per se? This case was decided, the reason there's a final judgment and the case is before us is that it was the defendant's motion for summary judgment was granted on the grounds of duty. Plaintiff's motion for summary judgment was simply denied.
Correct.
Which means that the negligence per se case is neither here nor there because the defendants didn't move for summary judgment, right?
Right.
So if we were to rule in your favor on the existence of a duty, does that get the job done, or do we still have more work to do?
Quite frankly, in all candor with the court, I think it does get the job done. It sends it back to the trial court where it should be.
Okay. There's really no. I'm interested in what result you would like to see, and of course I'll ask the other side the same question. But given that there were not cross motions on negligence per se, I am struggling to see what sort of a decision you want out of this court on that issue.
Well, Your Honor, in all candor, I would ask the court to look at Smith versus Owens, which is a Tennessee case which addresses exactly the issue of the code or the Landlord-Tenant Act in Tennessee.
Well, I'm less interested in the Landlord-Tenant Act and even less interested in Tennessee than I am in the procedural posture we're in and whether under the Arizona rules we should be considering the issue. So I'm very interested in your comment on that.
I understand that. I think it's...
Do we need to get there, I guess?
I'm sorry?
Do we need to get to that issue? Now?
No, you don't need to get to that issue right now. In all candor, this case should be reversed and remanded back to the trial court. At a very minimum, if the court finds that notice is required, Plaintiff has set forth enough facts for a question of fact as to whether or not the landlord had notice and should have done further by doing an inspection.
That may well be, but that was not the issue appealed, because the court never got there. The court never asked if there were enough facts to show notice. The court asked whether there was the notice sufficient to find a duty, which one might well argue was a misinterpretation of Gibson. But that's the way the court framed the issue. And that's what's before us.
You're correct. And my position is there was enough notice based on the facts to impose a duty. And
hold on.
I'm sorry.
Your position is that there was enough notice to impose a duty. Are you suggesting that notice even matters in imposing a duty?
If Your Honor and the court decides that notice is required to impose a duty, there was enough of a presentation for a question of fact for the jury. That's my position is and has been that notice is not required. You look at the statute, it says shall. It doesn't say that the landlord, if the landlord knows, there's no wording about notice in the statute.
So you don't need the statute because you've got Markowitz.
Correct, but the statute just furthers the argument. Notice is not required. If notice was required, then the landlord could sit and do nothing and say, I didn't go there, I didn't see anything, I didn't hear anything, I don't have to do anything. That's against public policy. That's against the statute, and that's against the building code. Thank you.
Thank you, counsel.
Thank you.
Counsel?
Good morning, Your Honors. My name is Vanessa Bragg. I'm here on behalf of the appellee, and this is Tico Glaves and Rochelle Prince with my office. I'm going to cut straight to the chase because I heard a lot of questions regarding notice and its applicability to duty in this particular case. And I would suggest to the court that notice, not necessarily actual notice, but notice is a prerequisite to duty in a premises liability case.
How can that be squared with the language of Gibson? Because it seems to me that Gibson, if it stands for one thing, people argue about what it stands for, but if it stands for one thing, it's that foreseeability is not part of the duty inquiry. And notice and foreseeability are inextricably intertwined.
Well, let me take a step back. I would agree with you from the Gibson standpoint, particularly in light of the recent case. I believe it was Quiroz, if I'm pronouncing it right. The recent Court of Appeals case was discussing how foreseeability goes into causation and damages. And I would say foreseeability from that standpoint, they looked at that particular case and rejected one of the restatements and actually took a look at it and said that not only did the incident have to be foreseeable, if you will, but the plaintiff would have to be foreseeable.
Well, and counsel, my reading of that Supreme Court case said it made it quite clear that foreseeability goes only to breach and not to duty at all.
Correct, and I would agree with you for that particular case from a foreseeability, but notice is different than foreseeability, Your Honors. And
What way? I mean, notice and foreseeability are two different words, but they seem to go to the exact same concept.
well, I would respectfully disagree, and here's the reason why. When you look at the historically the landlord-tenant case, they are saying that a landowner is not an insurer. It's not the same. And that just because an incident or an accident happens does not in and of itself mean that somebody is negligent or at fault.
I think even your colleagues on the other side would agree with that, and would say this is not a strict liability case. It's a negligence case. So we've established that, but that doesn't answer the question whether a landlord owes a duty to a tenant or whether a landowner owes a duty to an invitee. It would strike me as rather revolutionary to say that they don't.
I mean, you may be correct that there's no breach here, but surely there is a duty here.
Well, I would say that the case law indicates that a landlord has a duty to use reasonable care, warn of, safeguard, or remedy an unreasonably dangerous condition of which she had notice.
What you're talking about, though, is the content of the duty. And the content of the duty, whether we like this or not, the law is very clear that the content of the duty is decided on a case-by-case basis by a jury. The existence of the duty is a question of law for the court. And as I read Gibson, it seems that in those cases where there is no duty, that simply means that no conduct can create liability, period. You're just exempt from a duty to act reasonably, at least with regard to a certain class of people. You're not suggesting that we're in that situation, are you?
No, not at all, Your Honor. And I think that's why we have the cases that say you have a duty to use reasonable care to inspect of conditions, unreasonably dangerous conditions on the property of which you had notice. And that's why we get to actual notice, constructive notice, and then potentially the mode of operation rule.
So would you concede then that there is a duty? It's just a question of what that duty means in this case.
And I would absolutely, actually I would agree with you. And the reason why, if you look at the minute entry, and I believe I have it here, Judge, is because, and maybe the motion was not, the wording, if you will, in terms of MSJ on duty was not framed exactly as the MSJ was argued. And if you look at the minute entry, Judge Anderson's ruling, she took a look specifically at the same things that were originally starting to be argued before you in front of, by Mr. Victor. She looked at whether or not the prior tenants, the actual tenant, or anybody, the property manager who had been managing the property for 10 years, had reason to believe, if you will, that this particular structure was going to fail. And so...
But let me take you back to the minute entry.
Okay.
I'm looking at it now. And I'll quote directly. Before this court can address whether defendant Andrea Cash owed a duty to plaintiff, the court must first find notice. Could that be more wrong under Gibson? Gibson, I thought, made abundantly clear that the court must first entertain the legal question whether there is a duty without regard to the factual circumstances unique to the case. And the court here seems to be putting the cart before the horse by saying I have to engage in this factual inquiry before I can find a duty.
Well, and I believe, and I have actually Gibson with me, and I've read it as well, and I believe when you take Gibson in light of the cases that follow it, particularly with respect to our jury instructions, that basically we give a jury to decide. He specifically says the landowner has a duty if, and that's why notice comes in, and maybe it's juxtaposed a little bit with respect to duty and breach. Maybe there's a crossover, and I honestly do believe there is.
There's a problem with that because back in the days of the second edition of the Rajis, the Supreme Court used to approve them, and they had some effect of law. And now they're basically pieces of compromise put out by bar committees, but they don't have the imprimatur of the Supreme Court anymore. So if our jury instructions are talking about duty, I suspect that there are some involved with the authorship of Gibson who might disagree with those instructions.
Well, Judge, it sounds like when you say that a landowner has duty to use reasonable care, I believe that to be true. I don't think that imposes, though, that automatically with every premises case you're going to get to a jury, because that's essentially what the argument is. And that's why it's so critical that notice is attached to it. That's why every single case we have specifically states to remedy unreasonably dangerous conditions of which they had notice.
But I don't disagree with anything you're saying. It just sounds like you're talking about a stage in the analysis further down the road than the court got.
And they didn't, Judge. We actually were, it was dispositive motion stage. Discovery was over. And if I would suggest, I suppose, if you look a little bit deeper and go from the court finds that plaintiff has failed to establish notice, it talks about the deposition testimony of the former tenants. And in fact, if you look at the second page of the minute entry, Judge, you'll see that Judge Anderson took this into such a intensive analysis that she actually requested full deposition transcripts from the property manager, from Scott Bostic, who was the tenant before, was two tenants prior to Ms. Hamilton, from Carrie Rehome, who was the tenant before, and from Steve Heather as well, who was the Mesa manager. Mesa inspector.
Maybe what you're suggesting then, since you concede that there is a duty, is that we're getting hung up on semantics, and what this motion was really about was whether there was a failure of evidence to support going to the jury, assuming the existence of a duty. Would that be your fair summary?
Based on what you're telling me, yes, I'm going to agree with that for the time being. I will concede, for the sake of argument, that let's say a landlord has duty to use reasonable care to remedy unreasonable and dangerous conditions, and I'll just leave off the last part for a minute.
Well, so are you saying that under these facts, as we understand them, no reasonable jury could find a breach of the duty of care here?
Yes, I would suggest that as well. There was no expert. Mr. Heather, in fact, the Mesa City inspector, specifically testified that no layperson, no one, not even a contractor looking at, could have known about what was happening here. So they're utilizing after the fact inspections to try to establish something, to establish that all 9 of those homes, all 9 of them, everybody was essentially unreasonable.
All right, then let me ask this. Given the legal concession you've made, I think it becomes more fair than I expected to talk about notice. Clearly there's a concept of actual notice, which you claim didn't exist.
And the court did look to that specifically. It was fully briefed in our MSJ, as well as I believe we briefed it again for you.
Sure. Then there's the question of whether the landlord should have known of any defects, right? And that question, you may answer that in the negative, but it's a fair game to ask that question, right?
Absolutely, and that analysis was performed if you look at the briefing. In fact, that's why we even that's why the judge references carpenter bees and tiles and things like that. That analysis was performed, and it was plaintiff's duty to put forth any evidence other than speculative evidence at the dispositive motion stage as well. This wasn't a right out of the gate dispositive motion. This was filed after discovery ended, when our dispositive motion deadline was. So everything had been done. There were no experts, as in there were some 2 recent cases which they actually utilized as attachments for you. They were unpublished decision, and I believe, Judge Schwan, you were on one of them as well, where those were kind of coming out of the gate, but at the very least, the plaintiff, the person wanting to have the case get to a jury, they had evidence. In one of the cases, the defendant specifically told the person who climbed up on it that this was a rebuild, and it was such a shoddy rebuild. So there was this analysis, if you will, in that case, that a jury could find, based on the admission of the homeowner of this shoddy rebuild, that he should have done something more, potentially had an engineer go up before he had this painter climb up on the roof. And so this court found that got them to a jury trial because there was a question of fact that was created. In the other case as well, there was it involved a shade structure. I believe this was the one that you were on, Judge Swan. And that particular case, you're looking at whether or not the tenant, who had been living there for a long time and instructed the, I believe like a DirecTV repairman or something, to go up on this particular shade structure. There was a question of fact that existed. And so, given that you're not impressed with the duty argument, I will submit to you that if you read the briefing, the dispositive motion, the analysis that was performed was whether there was a question of fact as to whether or not the landlord or the property manager or any tenant or anyone had notice or could have or should have had notice. And that is specifically why Judge Anderson requested the full deposition transcripts, because there were some disagreements between counsel and I in terms of what each had said. And because Judge Anderson said, you know what, I'm just going to do this myself. I'm taking it upon myself because I think this is a critical issue here, and whether or not you get to a jury, actually read full deposition transcripts prior to issuing her ruling. And so while I suppose the wording, if you will, may be a procedural issue because it utilizes the word duty, technically the standard of review is to uphold the trial court's decision based on any reasonable ground. And I would suggest to you that if you looked at the record before you, and if you looked at the timing, and if you looked at the lack of evidence supporting, even plaintiff herself had no idea, said, yeah, I'd been there dozens of times, had no idea it was going to come down. Mom says, no idea it was going to come down. Everyone, no idea it was going to come down. Every single one of those homeowners, those 9 homeowners, had to all get notices afterwards. Take your thing down because it looks like there's something wrong here. No, there is not one bit of evidence. And so if you're not persuaded on the duty argument, where my analysis had been that notice is important to duty because of the case law I had read, and in my mind thinking that foreseeability must be a different concept than notice given the case law. But if you're not persuaded on that issue, then I will suggest to you that go deeper than simply one or two words in the judge's minute entry, because there was a full analysis done on what you would say notice, which would go to breach, and you have to have something to get to a jury before, on that particular issue, before you're going to be able to present it. And there was ample time, years actually, of litigating. This is a 2014 case, for someone to give something. So we would, I suppose, this is kind of taking a little bit of a 180, but I like it. We would ask that you take a look specifically at the record that was before the trial court and find that the trial court's decision granting the dispositive motion stands regardless of whether we use the word duty or notice. Because if we just would have said motion for summary judgment regarding notice, I suspect we wouldn't be necessarily having the conversation as much.
Let's, if we can switch gears for a moment to this negligence per se issue. Again, starting just with the procedural posture of the case, do you believe that we need to reach that issue?
No, Judge, because it was not appealed from.
And there was never a motion for summary judgment on the issue except by plaintiff?
Correct, and it was denied. And the case management, the appeal and the case management notice specifically said they were appealing from the judgment, and the judgment only pertains to the granting a defendant's motion for summary judgment on notice.
See, both sides agree. All right.
Do you have any further questions for me? Because I'd love to stand up here for another 5 minutes, but if you don't have anything further, I will sit down and not waste your time.
No, thank you.
Thank you.
And counsel, since we asked you quite a few questions, we'll give you 2 minutes for rebuttal. And a question I'd like to start out with, it seems like the argument has shifted to whether summary judgment was appropriate because no reasonable jury could find breach.
You're 100% correct. The argument has shifted, and just briefly, when you have Carrie Reholm's testimony, if you look at the transcript, and she talked about the 2 tiles blowing off the roof and calling apartment hunters, Tammy Fernandez sending someone out to get on the roof and replace the tiles or do the repairs, there you go. There's notice. Because a reasonable person would see the underlayment is missing, and Steve Heather said the underlayment is to protect water rot, and it's gone. A reasonable person who's on the roof, an agent of the landlord, would see that the lag bolts are missing, would see that the flashing is missing. So there is constructive notice, if not actual notice.
Which lag bolts are we talking about again?
That's a good question. We're
Holding
talking
the roof down or holding the swing up?
No, the lag bolts on the roof, not the swing. Because obviously when Steve Heather came out, you may want to look at a couple of the pictures in the response to the motion for summary judgment. The thing was a shambles. She had been pinned by the roof, and paramedics had to come with chainsaws and cut around her to lift up the roof and get her out of there. And then you have the Carrie Reholm's testimony about the carpenter bees burrowing into the post. Now, mind you, Carrie Reholm's testimony about the carpenter bees and about the roof tiles and the agent coming out to repair that and getting on the roof, that's all before Mary Hamilton's residency, before her leasehold interest. Mary Hamilton and her daughter, the guest, who's an invitee, would have no idea what transpired with respect to the roof, and they didn't get up on the roof. They're not in the roofing business. They're not in the rental property business. the landlord is in a much better position to know these things. In fact, they did, because they were put on notice about the carpenter bees burrowing into the post. All they had to do, Tammy Fernandez, is to send somebody out to check the post. If they were to check the post, according to Steve Heather, the straps on the bottom were rusted, were rotted away. These are things that...
Counsel. We appreciate your argument. Your time is up.
Thank you.
We do appreciate the arguments in the brief and their arguments today. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned.